Well, the Supreme Court has just ruled employers cannot fire workers because of their sexual orientation nor self-determined gender identity. The decision was based on the 1964 Civil Rights Act, which barred sexual discrimination in the workplace. Democrats applauded the 6-3 ruling. Speaker of the House, Nancy Pelosi, said in a statement, quote, "Today, the Supreme Court has unequivocally affirmed that all Americans, regardless of who you are or whom you love, are protected from discrimination in the workplace under federal law." Joining us now is Carrie Severino, president of the Judicial Crisis Network and a former clerk for Justice Clarence Thomas. Carrie, welcome back to the show.
Good to be here.
I'll get right to it. So a 6-3 ruling, and that includes Neil Gorsuch and Roberts both voting with the four liberal members of the court. That surprise you?
Yeah, it's very discouraging, not just because I think this is an incorrect result in terms of the statute. That's not what the language of the 1964 statute meant, but because the opinion was written in a way that I would say is sort of a sham textualism. It claimed to be interpreting the original meaning of discrimination on the basis of sex, but it's obvious that's not what the law meant in 1964. For decades thereafter, it's very clear that the many states who have enacted protections for gender identity or sexual orientation discrimination have done so using those words. So not by calling it discrimination based on the sex. So it's frustrating to see the redefinition, and as Justice Alito put it in his dissent, the court acting as legislation pure and simple.
What does it mean for Catholic and other faith-based organizations, the ruling?
Well, this is something that Justice Alito also pointed out in his dissent. There are some real issues that will be brought before the court. I think a tsunami of litigations coming based on religious freedom questions like in Hobby Lobby. Will religious employers be forced to cover transgender treatments or surgeries on their health care coverage? What does that mean for religious schools in terms of who they will be able to hire or be required to hire individuals who go against their own church teachings? There are a lot of areas that still have to be determined by the court, even going down to what pronouns one may be able to use. You have areas already like New York City that are forbidding use of any pronouns that other than those determined by an individual. So all of those, the courts are now going to have to try to work through. And I think that's more indication that this is not something that's always been in the law. This is clearly a sea change in the law, and that's why we're going to see so much litigation going forward.
Yeah, one critic of the ruling wrote, this will create chaos and enormous unfairness for women and girls in athletics, women's shelters, etc.
Yeah, I think that's a real area, whether women's sports can continue if men are required to be allowed to participate in those same sports. Bathroom usage, locker room usage. The majority opinion didn't want to take these issues on and kind of just brushed over them, but we can't ignore the practical realities of what's going to come from this dramatic change in the law.
So employers with religious objections to employing LGBT, do they have any recourse tonight?
Well, there is the Religious Freedom Restoration Act, obviously. There's the First Amendment that should protect churches and religious schools. But, there's a lot of attempts to narrow those protections as much as possible. We did see the court standing up for that in Hobby Lobby, but it's discouraging to see that there's yet another area that religious employers are now going to become embattled on here. So if you don't have courts that are willing to stand by the text of a statute, it makes us wonder then, are they going to stand by the text of the First Amendment of the Constitution as well?
Okay, well, it sounds like this isn't the final be-all, end-all, but is the court considering any other cases right now that you know of that might be of interest to the Catholic community?
Certainly. I mean, there's a major abortion case, the June medical decision, which has to do with holding abortion clinics to the same standards that other outpatient surgical centers are held to in Louisiana. We're expecting that to come down. The Espinoza case, which has to do with Blaine amendments, which were inaugurated really to stop public funding from being able to go to Catholic schools as part of an anti-Catholic initiative. We may see the opportunity for the court to finally end those discriminatory amendments for good. And then the Our Lady of Guadalupe school case is one that has to do with whether churches do have a religious exemption for being able to choose their own teachers to make sure the teachers are, in fact, in line with church teaching. The Supreme Court has already spoken on that, I thought pretty clearly, but the Ninth Circuit didn't seem to think so. So this may be the chance for the Supreme Court to go back and say, no, yes, religious schools really ought to have the ability to choose their own teachers. Otherwise, it undermines completely the message that they're trying to teach their students.
Appreciate your expertise as always. Carrie Severino, thank you very much, President of the Judicial Crisis Network. Check in with you later.